Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recorded live from FYP Studios East and West, transmitting across the internet. This is episode 337 of Registry Matters. Good evening, fine sir. How hot is it over there for you this evening?
It's only 90.
Jesus. I'm not going to say what I told you earlier today, but it wasn't nice, and it started with an F and it ended in U, because it's cold here, and I'm angry about it, and you've got glorious, glorious weather. Do you want to talk about your air conditioner? Are you going to teach it a lesson?
No, I don't do a lot of teaching with air conditioning systems.
You probably would try to do that if you lived here, because it's just an entirely different dynamic. It's kind of like your winters.
So absolutely, the AC is on the blinks, but repairs are underway, and I expect to have it running by the end of the week. And right now, it's a little toasty, but I'm cooling an entire house on one window unit. Now, can you at least admit that's funny?
Do you know how many BTU is it?
I think it's.
Well, you told me how many feet it'll try to cook.
Yeah.
Or cool. I mean, sorry.
It's rated for 200, and I'm trying to cool about 1,000, so that's a little bit above its capacity.
All right. Well, remember to show your support by hitting that like and subscribe button, 5-star rating in your favorite podcast app, even or not in your favorite podcast app. And it does help us out a lot. But so we truly appreciate your love. And in return, we're here to keep delivering the best content for you, whether we piss everybody off or not. And if you're feeling mighty generous, then please head over to Patreon and support us. And that would be incredibly awesome. We did get a new patron this week, too. I forwarded you an email from them. And can we talk about that tonight? That email?
It's in the show prep.
Oh, it is. Well, very good. You read my mind. And yeah, but then it'll come out as a normal podcast. You can download it in your player, and then as you're driving to work or walking the dog or whatever, you can listen to the show while you're doing those other things. Tell me what we're doing tonight, sir.
I hate to break everyone's heart because we have such a fine turnout tonight, but if you're waiting for the soothing voice of Chance Oberstein, you might as well leave now, because he's not able to join us this week, and probably not for the next month, because he's got some conflicts to resolve, and he'll make whatever announcements he needs to make about those conflicts, but he expects to be back by the middle of May. But tonight we have some listener questions, one of those you just mentioned, and followed by a main event, and then we have an article, if time permits, from the, I guess it's not really, well, it is from the Supreme Court of the United States, but we have an article that we may get to. We've got this case from the United States District Court from the Western District of Missouri, and there was that's our main event.
Well, fantastic. Well, let's do this somewhat of a detour. God, what was it, Larry? Maybe episode 20 or 30, the title picture is of a shower head. So what is this article?
Well, apparently I did not read it because of lack of time, and I figured there was a paywall. But Wall Street Journal and other entities have reported that the Trump administration has removed the requirement that restricts the flow of water through shower heads, and therefore shower heads will be able to pump out water again. And I love it.
And why does this matter to you? Sure, everyone loves to have a nice, powerful shower, but I'm sure there's a reason why we have restrictive shower heads.
Well, it's theoretically water conservation, but I'm not convinced completely about it, because in my mind, with my limited analytical skills, the water that we use today is the same water the ancient Egyptians used, and it's the same water that's always been here. So it seems like to me we're running just a giant recirculatory system. So I don't understand all the hoopla about water. The question is, how do we recapture it, purify it, and put it back for human consumption and use again? But this water we're using isn't about the same water we've always had.
Oh, I see where your logic is on that one. Well, what happens when the water runs off and goes into the ocean and becomes very, very, very salty? What do we do with it then?
Well, if you do what the Saudi Arabians and they do all over the Middle East, you do desalination, which is very expensive.
It's very expensive and very resource intensive. So if we can fire up some new nukes or coal-fired power plants, I'm sure that we could build some desalinization plants.
Well, we could do that, and we also sit in the largest source of fresh water on planet Earth with the Great Lakes. And I have to imagine that if we could engineer all the stuff we've engineered, we could probably figure out how to divert some of that water without drastically altering the lake levels that could potentially interfere with shipping. And I think we've got an ample amount of fresh water in the United States. I'm not as concerned about fresh water. Is it a problem in Arizona, New Mexico? Yes. But we're using the same water we've always used.
But yet, how would you get it from the Great Lakes down to the places that need it? I mean, that would have been a problem that we could have solved ages ago if it were like whatever scale of the word easy you want to put in there. Transporting water around would be insanely challenging. Not any more challenging. I can't imagine it would be any more challenging than moving oil, but there's a huge profit motive around moving oil from up in Canada, 2,500 miles down to Houston.
Well, that would be the challenge. It would be the expense of it, but it could be engineered to move water from the Great Lakes. I think we can build pumps, and I think we can build pipes.
Alrighty then. All right, well, let's get this show on the road and not talk about science and skepticism and all that stuff, and can we actually manage to do something? But I think this is the one that I sent you earlier today. I believe so.
Well, I think you sent me both of them.
I didn't send them today, though. Or maybe I did. Anyway, so this one is, hello. I would like some information on how to become involved with the efforts to restore civil rights for people like myself, which is kind of like we self. I don't have any real ideas of what I can do, but I would like to know what is being done so I can get an idea of where I might fit in. I'm an artist, and every time I get an idea for painting, I have to run it through the, will my probation officer allow me to paint this? What I do should be protected by the First Amendment. I should not have to wonder about someone else's opinion. I currently have some of my artwork in storage because they're considered pornography, but my probation officer, even though the images are not about sex, I would love to challenge the fact that I had to sign a fourth waiver for them to violate my Fourth Amendment rights, but for my First Amendment, they only need an opinion. I know while on probation, I must abide by the rules, but the catch-all of whatever probation seems necessary should not be carte blanche to violate my civil rights.
Well, I like that one. And it is not carte blanche to violate your civil rights. You do have certain rights while you're under supervision. But remember, you are being punished. And you are serving what was likely could have been a period of incarceration in the community, which means you do forfeit some of your rights while you're on probation. The question that he's trying to get at here is he thinks they're violating too many of his rights, and he doesn't know what to do about it. And the answer is not much. Because if you start pushing back on any of these conditions, they will tighten the screws more and more on you. They will find a way to start sending out teams of probation officers to search your house, to search everything, your electronic devices, and they will find something to violate you for. So I'm hoping you don't have lifetime probation, because I'm intending to say just write it out and get off supervision. But it did catch my eye about the painting. I never would have thought about or ever have heard of having to ask your PO, could you paint something before? I never would have thought of that. Have you?
I have heard something similar where people have some level of artistic creativity, and there's like the age-old question is, there's no definition of porn, but you know it when you see it, and they start crossing. He's not suggesting that he's trying to do anything of that sort. However, if you have material that depicts, if you're in a state like Georgia, if you have something that depicts adult interactions, well, you're not allowed to have it, even though you created it out of your head.
Well, their argument probably would be that those images can be used as a stimulation tool. And we can't have a person who's under supervision having any type of arousal or stimulation. Don't you understand that?
I understand that they have said those words. I completely disagree with it. vehemently disagree with it.
I do as well, but who's going to be the one to challenge it? The attorney has to be willing to stand there and say, Judge, we're going to have a full-blown hearing on this issue because they violated him for being aroused sexually. And I've got 37 witnesses I'm going to call to explain that it's a normal human condition to be sexually aroused. And Judge, you're going to have to sit through it and listen to it, and you're going to have to rule. Is this a reasonable condition of probation? Ain't nobody got no balls to do that. But that's what it's going to take, is someone to say this is an unreasonable condition of probation and be prepared not to just speculate, but be prepared with expert witnesses to explain the arousal, how it comes about, what can you do to suppress it, the consequences of suppressing it, and on and on and on. I would envision that you would need about a day's worth of testimony on this, and no telling what that expert would cost, because it would probably need to be a medical person, would it not? Or at least someone who had physiology about the human anatomy and how things work.
I believe so.
So let me ask you, listener, are you ready to spend that kind of money?
I can give you, there was a response to this email, and the person said that he's of limited means, as most of PFRs are. But really the question that he was then digging into is, what are these organizations, and he specifically pointed to Restore Georgia and NARSOL, what are we doing to fight back? That's what he really tied into.
That's a good question. I did see that part. I dropped it from this, but that's a good question. And the answer is we have to pick those fights, the organizations like Restore Georgia. I don't know their current bank balance. I haven't looked lately, but have you looked lately?
I'm the treasurer. So yes, I've looked right lately.
Well, let's just say without disclosing figures, do you think that your organization in Georgia is prepared to spend $10,000 on expert witness testimony for one particular case?
Negative, Ghost Rider. Negative.
And therein lies the problem that we face all the time. We have all these great challenges, and we don't have the money to facilitate many of them, so we have to choose so carefully of what we're going to spend those limited dollars on. What challenge rises to help the most people? Of all the people under PFR type supervision, I doubt very many of them are artists. So this doesn't affect nearly as many people as some other unreasonable conditions of supervision.
I mean, for that line of thought, we have people just trying to get general jobs where they can function.
We have so many things that affect the entire PFR population that we just don't have the bandwidth and resources to challenge. And therefore, this is probably a very worthwhile challenge to do. But it needs to be done correctly with an expert. It needs to be done correctly with a person who represents the individual that is not afraid to irritate a judge, because you're going to irritate a judge. Judge, I'm going to force you to hear this.
Summary judgment?
No, Judge, I'm going to force you to hear this. And Judge, you can lead on the state to dismiss the violation, or you're going to sit through a day and a half of hearing expert witness about why this is a ridiculous condition. You pick. And very few lawyers can do that to a judge. I'd have no problem doing it. It's my DNA makeup, but a lot of people can't do that.
All right, let's move over to question number 2. And says, I do have one question, though. Considering the recent PFR wins in Michigan, where we live, highlighted during your last show, as I understand it, it was reported that the duty to report employment, volunteering, and schooling was ruled not vague and constitutional. But a problem my son is facing concerns the fact that he will soon be employed, volunteering for NARSOL and others, and being educated online from the comfort of our home. Now, even the ladies at the sheriff's office where he reports don't know if he is required to report this, which has created a lot of confusion. Additionally, if we do not have to report this, no one understands what address to attach to these reporting requirements. I mean, it doesn't make sense that he should jeopardize potential life-improving activities like working, volunteering, and educating himself just because he, quote-unquote, might be required to report it. How is this making our citizens any safer? Isn't it just making it harder for my son to become a productive member of society? Especially there, if he's going to, especially NARSOL, if you volunteer, other than the conference, everything is remote. And then if you're going to an online college, Again, everything is remote. What address would you report of who you're volunteering for?
The hell if I know.
Why are you here?
So, well, that's quite a lot packed in. This is the one you were talking about from the new patron.
Yes.
So, yes, from Michigan. I don't know what to say because I'd like to think that there would be some guidance provided to law enforcement on this stuff. And hopefully by the time the conference rolls around in a couple of months, there will be more guidance. In fact, I think the ACLU released a statement, the ACLU of Michigan released a statement that gave some limited amount of guidance. But I'm not prepared to go through it today because I didn't prep for it. But it is very confusing. It's constitutional, but yet the people who do it say, well, how do I do this? What do I do? So that spells that guidance needs to be given at some level to the registrars around the state of Michigan.
An individual reporting to live in Michigan says that he was told reporting online school was not necessary when he tried it. But and then somebody else in his state, and he's in Arkansas, they made me in my state, he says. So God, now you're back to a hit or miss, depending on your PO or your handlers, your registry people.
Well, I always fall back on one particular thing that guides me with, if something is too difficult to understand, the criminal complaint has to be drafted if someone wants to prosecute you with specificity. And that hasn't changed in our existence. We have to tell a person what we're accusing them of doing, and we have to cite to the section of law that prohibits or requires them to do those things. And if this requirement is so vague that even law enforcement can't understand it, a successful prosecution will be highly unlikely. But that doesn't mean that one couldn't happen. It just means it probably would not be sustained with a conviction. But very few people want to have to post bond or be held on a no bond hold, all sorts of things that go along with it, while they're waiting for it to be resolved downstream. They'd like to know now.
So if the people that you go register with and you say, hey, I'm thinking about enrolling in this school, and you go down and say, I'm going to enroll in this school because I'm required to register, and they go, I don't know what you're supposed to do with that. What do? Do you then hold up registering for school? Or that's putting your whole entire life on hold while they go, I don't know.
No, you don't do that. You go ahead and register for school.
Okay.
And you go on about your life.
And when they knock on the door and tell you that you're violating, you de-enroll, or you go in front of the judge and go,
who would be the they that would knock at your door? The very few people, the very same people in most states, the people who are authorized to initiate violations of Registration Act are the same people who register you.
Right.
As a general rule, and I'm not saying this is absolute because I don't know it to be absolute, but as a general rule, only the registering entities can prosecute people for PFR violations. So here's the way this would go down. So you're saying that the people in Michigan who wouldn't take the information would run down in the middle of the night with a complaint, and they would say, Andy didn't report this. Well, what do you reckon I would do as a defense attorney? I would call them and put them on the stand. And I would say, well, wait a minute. Now, you swore out a complaint, and you're saying that the person didn't do something. According to my client's records, he tried to give this information to you people on this date, and you told him you didn't know whether or not he was supposed to give us information. So now you took out a criminal complaint. Do I have that correct? And the complaint would go nowhere. So if you people out there are documenting everything, and when I say documenting, I mean the best you can with the resources you have. Some PFR offices don't let you take your phone in with you. Some do, some don't. So if they don't let you take it in, you can't hit record. But what you can do is keep a journal of who you dealt with and what you tried to do and the date you did it. They can't prohibit you from keeping a journal, can they?
I don't imagine they could, but they could, if they want to be real dicks, they could confiscate it when they come toss your house.
I ain't never heard of that in my 99 years of doing this.
But if I can think of it, I'm going to use your expression. If I can think of it, they could think of it.
Well, if that be the case, then you need to digitize your journal and make sure that it's not only in written form, but you've also entered in a journal entry somewhere that's stored on the cloud. Hopefully, they won't be able to delete that.
Absolutely. I see. I'm the one that would come up with those things of like, well, you could do this, and then you go, well, that's too technical. That would be your response.
Well, it's not all that technical to write an email, is it?
It is not.
Well, you'd write an email to someone saying, I went to the PFR office today. I tried to register my online school. They said no. And then you would have that you could print, say it was written in real time, that you tried your best to report it and they wouldn't allow you to report it. The case would go nowhere. But it's mind-boggling, and it's also anxiety for people.
Without a doubt.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
You want to talk about Missouri?
Not really.
Well, you put this decision that came out about roughly a week ago from the District Court for the Western District of Missouri. And I'd have to get our resident Missouri person to tell me if I did Missouri correctly. Now, I read it. I spent all morning reading this, Larry. And I agree with an observation made by the paralegal. And he said, I've never seen a faster decision. I think you have some credentials as a paralegal. Have you seen anything that quick?
I can't think of anything that's come down this quick after the trial. It was very quick after the bench trial.
And this is the case of Jane Doe versus Michael Turner et al. And the case number is 21-04102-CV. Now, was this a victory for PFRs?
Not really. It appears that we lost big time.
Could you say that part again? We lost what?
We lost big time.
Oh, geez. So who is the defendant? The defendant's name is Michael Turner, and that doesn't ring any bells to me. Does it ring any bells to you?
No, but it was explained in the case that Michael Turner succeeded Christopher Olson as the Missouri State Highway Patrol Superintendent and Commander. Thus, he was substituted in the case in Olson's place in his official capacity, which is how these suits go down, pursuant to the rules of federal rules of criminal procedure. Nobody cares about the rule number.
The decision states, plaintiffs asserted several constitutional challenges to Missouri's PFR Registration Act, which is SORA in that state, Missouri's version of Megan's Law. Now, did they prevail on any of the claims?
They did prevail on one claim.
The order states the court previously dismissed some claims and granted summary judgment in whole or in part on other claims. The summary judgment order also substantially narrowed the remaining claims. The court conducted a bench trial on March 24th and 25th in 2025 to permit presentation of evidence and legal argument. Was summary judgment a problem in this case as it is for all but one case that I can ever remember?
I don't know, but I'm leaning toward yes, it was a problem, partially, but I don't want to emphatically say it was. I think it was.
Well, let's do some background on this. So the current version of SORA requires any person convicted of specified offenses to, within 3 business days of adjudication, release from incarceration, or placement upon probation, register with the chief law enforcement official in the county in which such person resides. Now, to register, individuals must provide their address, social security number, butt print, phone number, the IMEI number, or any other online identifiers they use, a description of their vehicle, details of their employment, and description of their conviction. Wouldn't they already have the description of the conviction? They must also provide their fingerprints, a current photograph, and, of course, a DNA sample. This information is to be provided on a form prepared by the Missouri State Highway Patrol, and registration must occur in person. Now, this sounds, for the most part, very similar to what other places do.
What about the butt print? Where did that come from?
That came out of me just making up stuff, because this is a pretty thorough list.
It does sound very familiar, and I'm adamantly opposed to having people register with law enforcement for what something has been designated as a civil, non-punitive regulatory scheme. PFRs need to learn to make that argument to their lawmakers. But first, they have to learn how to say civil, non-punitive regulatory scheme with a straight face, which I can do and most people can't.
I don't think I could ever say civil non-punitive regulatory scheme with a straight face. So what about changes and or updates? What do they have to do with those?
Well, after registration, individuals must report changes to their information within 3 business days. As with initial registration, such changes must be made in person. Now, that I vehemently disagree with, but that's the law in that state. I think that in this modern age, we could report changes online. But however, a separate provision requires changes to the use of online identifiers to be reported in person before the new identifier can be used.
Well, that's kind of inconvenient. Now, you said that before that you can use it?
I did. Can you at least admit that's funny?
So I'm going to, I buy a new iPhone and I'm going to go register an iCloud account. Now, before I activate the phone and register that I can use the phone, I have to confirm with law enforcement that this is okay for me to register the identifier?
Well, not that it's okay, but before you use it. So that's what I'm wanting you to admit that's funny. You have to register your online identifiers before you use them.
I'm going to go down and buy this new iPhone. Like, that's a pain in the ass. No, it's not funny, Larry. But your definition of funny becomes more disjointed every time, every episode. Do they have a tier system in Missouri?
They do, but they use the categorical approach, so meaning that they don't do individualized assessments. SORA groups registrants into 3 tiers. Sounds familiar, does it?
It does.
Placement in a tier is based on the crime committed and is intended to be based on the seriousness of the crime, and although no individual risk or other assessment is made for each registrant. These tiers impact the amount of time a person must remain on the registry. Tier 1 must register for 15 years. Tier 2 must register for 25 years. And Tier 3 offenders must register for life. The tiers also dictate how often the person must register. Tier 1, annually. Tier 2, semi-annually. And Tier 3 must register every 90 days for life.
This case has been going on for years. Plaintiffs filed this action in May of 2021. Do you think that this is normal? That doesn't seem that bad.
It's fairly normal for cases challenging constitutionality. They drag on for years. They're not highly prioritized. And also, it's just the complexity of them. And that's also is a contributing factor to the enormous expense. But yeah, it's not that uncommon.
And it was also an et al., and I don't know how many people are in that, but that also then means you've got to deal with all of the et al. People.
That is correct, and I don't know who they are either.
They asserted a plethora, a cornucopia of claims. Several were dismissed during the litigation. Do you mind if I read through the ones that are still remaining for them to decide?
Sure, I'm glad you're reading them, not me.
Because there's 80 of them. Just kidding. There's, 6 of them. Count 1 alleged SORA violates the 8th Amendment's prohibition on cruel and unusual punishment. I've heard that before. Count 2 alleged SORA is an unconstitutional ex post facto law. Count 10 alleged SORA's definition of online identifiers violates due process because a portion of it is unconstitutionally vague. Count 11 alleged SORA violates the First Amendment because it infringes on plaintiffs' ability to engage in speech and associate with others. Count 12 alleged SORA violates the First Amendment because it interferes with plaintiffs' ability to engage in protected anonymous speech. Count 13 alleged SORA's requirements that online identifiers be disclosed before they are used constitutes a prior restraint on speech in violation of the First Amendment. Okay.
All right. Well, having now, see, this is just the counts that weren't already dismissed or decided summary judgment, and these were remaining to be decided. But of these remaining counts, only count 10 survived.
I'm assuming they use the famous Kennedy-Mendoza-Martinez factors to determine the registry as punishment.
They did. What made you assume that?
Because they're listening to this program and you talk about it regularly?
Well, and they did, and they said, having addressed the Smith factors and at Smith versus Doe, individually, the court now considers them together. They stated SORA is not comparable to a practice historically regarded as punishment. How many times have you heard me say that?
I'm trying. Wait, can you say that in another way for the dumb people?
They stated that SORA is not comparable to a practice historically regarded as punishment. Remember, we have to interpret based on what the words would have been understood to have been meant at the time they were written. So when they adopted the cruel and unusual punishment clause, a registry scheme would have never been thought of and considered punishment.
Okay, I'm with you. If you can put someone in the town square and parade them around and whatnot, that's not considered cruel. So just having your name on a website's not cruel.
That would be it. Now, so those of you who claim that you believe in original interpretation and all this kind of stuff, that's fine, but this is what you get. But they said SORA does not promote the aims of punishment. Instead, it serves a non-punitive purpose of alerting members of the public to the presence of PFRs in their community and aids law enforcement in investigation of crimes. Finally, SORA does not impose any affirmative disabilities or restraints, and I was shocked to see that. To the extent the requirement in person reporting qualifies as a disability or restraint, it is rationally related to SORA's non-punitive purposes. Accordingly, the court concludes that SORA is not punishment within the meaning of the Eighth Amendment.
Well, then what about ex post facto clause raised in count number dos, or number 2?
Well, the ex post facto clause prohibits Congress and states to enact any law which imposes punishment for an act which was not punishable at the time it was committed, or imposes additional punishment. And they stated, for the reasons previously discussed, the court concludes that SORA is not punishment and therefore cannot violate the ex post facto clause. So they weren't too enamored by that one.
So then individuals subject to SORA must register their online identifiers with the chief local law enforcement officer, and failure to report them is a crime. An online identifier is defined as an electronic mail address or instant message screen name, user ID, cell phone number, or wireless communication device number, or identifier, chat, or other internet communication name, or other identity information. Count 10 asserts one item on this list. The catch-all phrase, other identity information, is overly broad and vague and fails to provide adequate notice regarding what must be reported. It sure does seem vague to me. Can you at least admit that it's a bit vague, Larry?
I can, but unfortunately, that is not where this analysis ends. It's the beginning of where this analysis goes. But yes, the way that's worded there, that standing alone would be vague.
Now, so what do you mean? Can you explain the void for vagueness doctrine?
Sure. The void for vagueness doctrine is embodied in the due process clause of the 5th and 14th Amendments. It dictates that a law is unconstitutional if it fails to provide a person of ordinary intelligence fair notice of what is prohibited so that they can conform their behavior to the requirements of that law, or are so standardless that it authorizes or encourages seriously discriminatory enforcement. A statute violates the void for vagueness doctrine when criminal liability is based on wholly subjective judgments without statutory definitions. We can't have people guessing at what the law requires. We have to tell them. And that's what makes a law void for vagueness. So that other identifiers was too vague. But then when we get further down here, I'll explain how they fix that.
So then how can this claim be overcome if that's the case?
Well, I'll let the court explain. The decision states the court rules for the defendants because in their administration of SORA, they have clarified and specified the meaning of other identity information. When evaluating whether a statute is void for vagueness, the court must consider whether the statute has been narrowed or clarified by, for instance, a state judicial decision or regulations. And can you read the remainder? It's too much reading for me to do.
I understand. The current version of the form, which has been in use since 2018, was admitted into evidence as Defendants Exhibit HH. I assume, Larry, that means we made it all the way through A and went through A to Z, then B to Z, and now we're at HH?
That would be correct.
Holy moly, that's like 500 exhibits?
Not quite that many. The alphabet doesn't have 500 letters.
26 to get to then H, which is HIJ, the 8th letter. So 25 times 8 is 200 and change, right?
They might not have used that system as you're envisioning it, but yeah, they had quite a few exhibits.
Okay. All right. So Exhibit HH, and it lists the information registrants must provide. For instance, registrants are asked to provide IP addresses, but are not asked to provide information about cookies. Therefore, registrants do not have to guess what the phrase other identity information means or harbor doubt about what information they must provide. The form asks for IP addresses, therefore, plaintiffs must provide IP addresses. The form does not ask for cookies, therefore, plaintiffs need not volunteer information about cookies. I have a lot of problems with that paragraph right there, Larry.
Well, it's over my head, but I can tell you that when you're doing litigation, you've got to carefully scrutinize what judicial decisions have been made, and it would pay for attorneys to consider any narrowing that has been done by a previous judicial ruling or administrative regulations, because if those narrowings have already taken place, then you don't have a viable constitutional claim, because the scope of the law has been clarified either by judicial determination or by administrative clarification.
Do you mind? Can we move over to the prior restraint, which is count 13?
Sure.
All right. Well, under SORA, registrants must report any changed or new online identifiers in person to law enforcement before using them. God, that's just bizarre. Missouri Revised Statute 589.414.9. In contrast, changes to other types of information, such as your address or employment information, must be reported within 3 days. So for that, you have to do it in advance of, but for physical kind of things, you can do it within 3 business days. All right. Can you please tell me that that's some form of prior restraint?
I can grudgingly admit that, yes.
The court held and continues to hold the requirement for identifiers be reported before they are used is an unconstitutional prior restraint on speech in violation of the First Amendment. The court stated, in summary, while plaintiffs' online identifiers and speech are not subject to defendants' approval or disapproval, plaintiff's speech is subject to criminal sanction until they comply with SORA by registering any new or changed identifiers. As the court explained, this is not something that can be done on the spur of the moment. Registrants cannot lawfully use any new or changed identifiers until they personally appear at the local law enforcement office during business hours. Therefore, plaintiffs' ability to speak lawfully depends on first complying with SORA, which prevents or delays their exercise of their First Amendment rights and therefore makes the requirement to register in advance a prior restraint. Do you want me to continue?
Sure, go ahead.
All
That
right.
saves me.
That's fine. So then the court stated, at trial, defendants did not attempt to justify the need for plaintiffs to comply with SORA's requirement before engaging in First Amendment activity. The court therefore adheres to its conclusion that requiring registrants to register new or changed identifiers before speaking violates the First Amendment. Moreover, the requirement is invalid on its face because there is no set of circumstances in which this prior restraint can be justified. Now I see what facially unconstitutional means.
Very good, and you don't need me.
That's it, you're fired. So I will ban you from the Discord server. On page 17, it states, the remaining issue relates to the appropriate remedy. Plaintiff asked the court to strike the requirement that online identifiers be reported. But this is not appropriate because the registration requirement, as a whole, is not unconstitutional. The only unconstitutional aspect relates to the timing. The court also cannot bar enforcement of the deadline in subsection 589.4149 because defendants have no role in SORA's enforcement. Now, what does that mean when they say that the defendants have no role in enforcement?
The way I'm interpreting that, it means that you have to file your complaint against the correct parties. This is naming the state highway patrol, and apparently the state highway patrol does not enforce Missouri SORA. Apparently it's local law enforcement that does that. So I'm just curious. We don't have an attorney guest from this case, but I'm curious as to why they didn't name the people who actually enforce. At least a couple of them enforced the law. I don't know whoever all those people at all include, but you got to have the right parties. You can't prohibit someone from enforcing something that they don't have enforcement power over.
If I do computer work for you, aren't I the one that's bringing the expertise to the table so that I deliver the right product to you because you don't know how to do it?
Well, yeah.
Isn't that why I would then hire an attorney, because they went to Attorney 101 and they would know how to figure out, like, well, gosh, who's the right party to name as a defendant? Wouldn't that be Lawyer 101?
It's not quite that simple. I do agree with you generally, but trying to figure out the right responding party can be exceedingly complicated because you're trying to do, at least I know when I'm involved in a team, we're trying to figure out the best venue that we're going to file in if we have an option of filing in different venues, whether we're going to go state or federal. And we're trying to figure out who the name is the responding party, whether we can ground jurisdiction in that responding party. And will that responding party be more reasonable? There's so many factors, but yes, you should take everything into account and try to figure out who all the proper respondents would be named in the lawsuit. But the more responding parties you name, the more complex the litigation becomes.
But again, so if you want to just play Pac-Man on your computer, then we can deliver you a pretty simple machine. But if you want to do contact tracking and emailing and other things, then we have to make it a more complicated system. Therefore, it costs more, et cetera, et cetera, et cetera. Like, just seems like this would be kind of part of the basic thing that a lawyer would do. That's why you're hiring them for the tens of thousands that we talked about earlier.
Do you actually think that just because a person has a law degree that they can come up with every answer?
No, I decidedly know that that's not true.
It doesn't work that way, but it is complicated trying to figure out some of these issues. So I don't want to ding them for that because I don't know all the backstory of why they chose the respondents that they chose.
I also see that on page 17, during the trial, the court discussed with the parties the viability of directing the Missouri State Highway Patrol to amend the form to remove the time limitation in the 6th paragraph, which would leave the broader time limitation requiring that the information be reported within 3 business days. Defendants, while not conceding in that statute is unconstitutional, agreed this was a workable solution. Therefore, the court, number 1, grants judgment to plaintiffs on count 13, and 2, orders defendants to modify the form given to chief law enforcement officials to remove the directive that new or changed online identifiers be reported before they are used, as it currently instructs in the 6th paragraph on the 4th form, on page 4 of the form. Is this all they want?
Yes, it's all they want.
So they don't have to report in advance of, so they can buy their iPhone and use it immediately, but be at the office before it opens at 9:00 on Monday, or else you're in trouble. Is that what I'm reading?
Well, the agreement seems to reflect the order is going to give them make consistent with the other reporting obligations within 3 days. But yep, that's what they want.
Okay, then what? What happens next?
Well, an appeal is likely to the 8th Circuit. According to one of the attorneys that's very familiar and involved with the case, he announced that, but I'm not seeing a whole lot of fertility in that appeal. But again, I'm not directly involved in the case, but it looks like it's not going to be one that's going to be easy to turn around.
And so clarify for me, do they get to relitigate? I don't know. That's probably not the right word. Do they get to appeal all of the counts, or is it only this particular one, count 13?
No, if they were to take it up on appeal, they could, unless they stipulated the dismissal of certain counts, they would be able to raise an appeal on all the counts they lost on. But that's not a wise appellate strategy because that's too many counts, in my opinion. I would try to pick what I thought I had the most evidence in the record to support. And again, I don't know what's in the record because this case has been pending for years. It would take quite some time to figure out what else in the record. But I would narrow down my scope of the appeal and try to focus on where the record is the strongest, if the record is strong on anything.
Okay. Any final words?
I feel bad for the people in Missouri that were hoping for a great outcome because this is going to be a tough one to turn around on appeal. It's. I thought that the Georgia case for the sheriffs was tough to turn around on appeal, but this is way more complicated to turn around on appeal.
I see. All right, well, let's cover this article. And this is from Courthouse News Service. And the title of it is Alito, Gorsuch urged Supreme Court to consider nuance of defendants' right to confront witnesses. God, I have a quote from Scalia somewhere, and I don't know if I actually, I don't think I have it queued, where it's something about having the right to, this is the Eighth Amendment, if I'm not mistaken, to confront your witnesses. And they turned down a request to pin down the meaning of an out-of-court testimonial statement, which justices previously found can't be used as evidence at trial because the Sixth Amendment guarantee that lets defendants, it's the Sixth Amendment, guarantees the defendants can confront their accusers. So this is good, or is it not?
Oh, it's good, at least for the moment. And your recollection is good. Scalia was extremely adamant about the confrontation clause. He wasn't all that favorable for accused on many issues, but on that one he was good. Unfortunately, although this is good at the moment, the warning signs are there to be concerned about. Justice Alito and Justice Gorsuch wrote separately, which is unusual in a cert petition, respecting the denial of the cert, but urging the court to reconsider its interpretation of the Constitution's confrontation clause, which ensures the right to face witnesses in person and cross-examine them. And I say it's a warning sign because everybody's rooting for more conservative appointments. And if we get enough conservative appointments that think along that line, this confrontation clause may go away.
Huh. And as we've already stated, so Scalia was really, really strong on this particular issue, right?
He was, and in fact, I think he penned the majority decision in the case of Crawford v. Washington, and that's where the high court, where they found the clause barred the use of any testimonial statement made out of court by a person who could testify and hadn't already been cross-examined by the defendant. However, Alito wrote that this ruling has not produced predictable and consistent results. Well, I don't guess it has, because we need more convictions. And despite repeated attempts to explain what Crawford meant by testimonial statements, our confrontation clause jurisprudence continues to confound courts, attorneys, and commentators. And that's what the George W. Bush appointee wrote.
The rejected case comes from Sid Franklin, who was arrested in New York following a road rage incident in which he threatened nearby motorists with a gun. Police searched the basement of Franklin's home and found a gun in a closet containing items belonging to both Franklin and his stepmother, who lived at the house along with Franklin and his son. While Franklin awaited arraignment in Queens Central Booking, a criminal justice agency employee interviewed him for a bail report without a lawyer present and recorded his address as the basement of his home. This information was central to the prosecution's case and Franklin's weapon possession conviction, as there were no DNA or fingerprints discernible on the gun, and there was no other direct proof that Franklin lived in the basement. Franklin argued that this use of the bail report violated his Sixth Amendment rights since he couldn't cross-examine the report's author at trial.
Unfortunately for him, the New York Court of Appeals disagreed, concluding that the bail report was not barred testimonial statement because it was written primarily for administrative purposes and not for use at trial. Justice Gorsuch stated, "It's hard to fault the Court of Appeals for applying a primary purpose test in assessing Mr. Franklin's Sixth Amendment claim." I don't exactly know what that means, but it sounds like he thinks it's okay.
The article states that the Donald Trump appointee noted that such tests, where a court must objectively determine an out-of-court statement's primary purpose, were endorsed by the justices last year in Smith versus Arizona. But even if that judge-made test may have some useful role to play, it seems to me that treating it as a necessary condition to relief under the Confrontation Clause can pose problems too, risking results that sit uneasily with the clause's original meaning. It is a concern I raised in Smith, and one that, to my eyes, this case highlights. That's what Gorsuch wrote.
And so, again, I'm seeing warning signs, and Gorsuch also expressed concerns with the challenges of determining the primary purpose of out-of-court statements, which can range drastically from eyewitness at a crime scene to expert forensic analysis. This process consequently leads to different results from different judges in similar cases, he wrote. So it sounds like to me they're looking for an opportunity to revisit the confrontation clause, and Scalia would be turning over it in his grave.
Interesting. And why do you think that they would be doing that? Can you put on either sinister or altruistic hats and give me an analysis of why you think that this is happening?
Well, it's like everything else. There are people who advocate for victims that believe that every case should result in a conviction. And they see these things as technical excuses to allow people to get away with criminality. And therefore, this confrontation clause is very expensive. Witnesses cost money. When
Sure.
we send something off to a lab, we don't know how far it went. It may have been an in-state lab, it may have been out of state. But the expert is going to be expensive to fly in. You may have to fly them in multiple times if there's a continuous at the last minute. And it's just cumbersome. The administration of justice costs money. And this is a way to dispense with that in-person direct confrontation. I mean, we can read the report. We know what the person said, but we can't ask the person any questions about what their motivations may have been for writing what they put in the report. So therefore, it does exactly what Scalia said. It undermines you shall be able to confront your accusers and the witnesses against you, and you can't do that.
I gotcha. Well, as always, Larry, you make it really depressing and sad at the end of the show. So thank you for that. Appreciate that.
I'll do the best I can. And
I figured that this would be the show that you run everyone else off. So thank you again for that.
so, well, I do my best. I'll hope to do better going forward.
Well, please head over to registrymatters.co. Oh, before I do that, Dawn, thank you very much for becoming a patron, and we covered your question there, and I hope that helps you to some degree. But again, head over to registrymatters.co for show notes, and that's where you can find where the links are to download the podcast on your podcast player app of choice. And email, as some have done, registrymatterscast@gmail.com. I offered it before. Support us on Patreon, patreon.com/registrymatters. And also, please, you can head over to the Registry Matters swag shop, and there's some cool t-shirts and other things there. And that's FYPeducation/shop. Larry, I hope you have a fabulous weekend. And boy, like I'm so sad that it's 90 degrees where you are. I'm really so upset that it's that, like, ugh. Really?
Well, you know what'll be funny about my experiment of trying to cool the whole house with a single room unit? It's going to be funny if I burn up that air conditioner and I go home and I have no air conditioning. Can you at least admit that's funny?
And then you try to go buy one and it's peak season and you can't find one, and anyone that you find on Craigslist or Facebook Marketplace is triple marked up.
That would be even funnier.
That would be fabulous. Well, my friend, I hope you have a fabulous weekend, and I will catch up with you sometime soon.
Good night.
Take care, everybody. Have a good night.
You've been listening to FYP. You've been listening to FYP.